There is nothing new in the realization that the Constitution sometimes insulates the criminality of a few in order to protect the privacy of us all.
It's a price we're willing to pay as Americans.
Remember, we're talking about the plain view doctrine.
That's a good point.
Okay. Yeah. It doesn't say plain touch, plain move, plain look around, plain look underneath. It's plain view. Am I an idiot? I think that is what the words mean, what they say they mean. All right, well, welcome back, Ryan. We were just talking today about how we inadvertently both wore blue shirts.
Yeah, we didn't call ahead or anything.
Nothing. I went to court this morning. I handled 2 hearings. You went to court this morning. You handled a hearing. How'd it go?
We even have the same colored suits on.
Pants.
Yeah.
Looking sharp today, Ryan McPhee. Always a pleasure to sit here with you. Today, we're going to actually do something a little bit different. I think from the start of our podcast, all we have really done are murder cases. I can't think of one that wasn't a murder case.
Right. All homicides so far. Well, Miranda.
Miranda was not a murder case. That was a kidnapping case. Still a violent felony and a little bit gruesome facts, but not nearly as bad as what we've done in the last 2 weeks. So we're going to kind of take a breather from the heavy-hitting homicide stuff and still talk about a criminal case here in Arizona. In fact, another one that went all the way up to the U.S. Supreme Court, but with facts that are a lot less heavy.
Yeah, but at the same time, here's how it aligns with kind of what we do, in that what we focused on, we do talk about obviously the facts of the case, the story of the case, some of the investigation, but we really try to focus on helping people understand the legal issues that happen in a case. And this is a case with really important legal issues that people ask us about all the time and that are involved in a lot of different types of cases.
Totally. I agree with you. One of our goals for our podcast, this podcast, is to educate our listeners so that they can understand the law. And I think this one is a real-world application of law, constitutional law, Fourth Amendment law, search and seizure law, that a lot of times people are very interested in about. So I'm going to dive in. Okay, Go ahead.
And search and seizure. So it really is kind of, that's what this case is about. And it's a really interesting issue where 2 people might hear it and hear the facts and be like, well, yeah, of course somebody can have their stuff searched and seized that way. And somebody else might hear it. And we're going to have, U.S. Supreme Court justices who disagree on this.
And that's a great point, right? So 2 people off the street may say, I see it this way, I see it that way. And you have 2, 3 really, very high-level justices. I mean, highest, court in the country. Several of those justices don't see this case in the same way. And I love it. Yeah. I think it's great. Now, I guess just to set the stage just a little bit further, when we talk about search and seizure, we're talking about Fourth Amendment, a reasonable expectation of privacy. And on its face, that may seem simple, but boy, there are so many nuances with the Fourth Amendment. What is considered reasonable under the circumstances has been the subject of debate in thousands of cases.
Yeah, and I guess the general rule for people, the Fourth Amendment, says that the people of the United States should be free from unreasonable searches and seizures of their items and themselves.
That's right. So we're going to turn the old clock, go in the Wayback Machine again, to April 18th, 1984. Here in Northwest Phoenix. Again, this is an Arizona case. Even though it's a U.S. Supreme Court decided matter, it happened in Arizona. And that's what makes it especially fun for us because this is local. So what I'm going to do, as we've done many times, is simply read the facts of the case as they were presented at trial. And this was the rendition of facts as laid out by the Arizona Court of Appeals. This was the decision that was rendered prior to going up to the U.S. Supreme Court.
And this is basic. People know this probably, but it's, it has to go through a process as far as appeals go. It goes within your state, up to the Supreme Court, the Court of Appeals of Arizona, then the Supreme Court of Arizona, then the U.S. Supreme Court. And obviously there's a lot more complicated there, but this is the U.S. Supreme Court talking about the Court of Appeals of Arizona and their decision.
Actually, no. I'm going to read from the Court of Appeals decision. This is before it hits the Supreme Court. The Supreme Court does take these facts because this is what's in the record. But I think the Arizona Court of Appeals does a little bit better job of providing us with some detail. And so that's what I'm going to do. April 18th, 1984, I was 6 years old at the time, for context. All right. Police officers responded to a shooting at an apartment in North Phoenix. The victim had been shot through the floor from the apartment above. The officers were admitted to that apartment by the manager of the complex. In a quick search, they determined that no people were in the apartment. They did, however, seize several weapons. One of the officers, on seeing expensive stereo components, which he believed to be out of keeping with the otherwise mean nature of the furnishings, became suspicious that those components were stolen. He moved the components so that he could locate and record the serial numbers. That fact becomes really, really important.
Yeah, it's really interesting, right? Like he walks into an apartment, and they'll talk about this, but he had basis to do that, the officer. Goes in there, sees it, you say, oh, it's a stereo. How could you think that it's an illegal stereo? But apparently it's just a crappy apartment with very scant things and a really nice stereo.
That's right. And in fact, not to spend too much time on the stereo, but I did a little bit of digging. Okay. So that stereo equipment, at least the turntable, record player,
very nice,
was what they call a Bang & Olufsen turntable. So I'd never heard of that before, so I did some research.
Good sound
Super
equipment.
expensive stuff.
Currently,
like speakers, $10,000 speakers, $15,000 speakers, and these are little, home style stuff. So super expensive stuff.
I was looking at their over-the-ear headphones, and they were something like $3,000.
Right. So expensive stuff. So the officer goes in. He sees some of this expensive stereo equipment. It catches his attention. In any event, I'll keep reading. On checking by computer and department reports, he learned that these components had been taken in an armed robbery. These facts were supported in an affidavit. A search warrant was issued, and the components were subsequently seized. The state appeals from the suppression of the evidence. Okay, so again, shooting from the apartment above into an apartment below. They're searching the apartment above, and the basis for that search would be an exigent circumstances situation, meaning there's no time to get a warrant. There is probable cause to believe that a crime occurred from that original apartment above.
But see the bullet hole.
Right, and somebody was injured down below. And so the law allows officers to go in without a warrant, search for weapons, search for people, and secure the scene. In securing that scene and doing that initial search, yes, they find some weapons. Yes, they find some indicia of possible shooting. But during that search, the officer then sees this expensive stereo equipment. He thinks these two things don't add up. Crummy apartment, super expensive stereo equipment. I think that forms the basis of a potential criminal investigation. The interesting part here, and this is so important, is the officer didn't just see that stereo in plain view. In order to get the serial number, he had to move it a little bit. He had to manipulate that stereo to then read the serial number, do some background searching, and then determine that that was part of something that was stolen in an armed robbery. And I should say, we never introduced the case. This is Arizona v. Hicks is the case. The defendant was James Thomas Hicks, and again, this happened in 1984. So what happens at the trial level? Defense counsel picks up on this, and they file a motion to suppress. Judge, that was an unlawful search and unlawful seizure or unlawful search of his apartment. Now, officers are in there based on exigent circumstances, which allow them to do the search, and the stereo equipment is in plain view. Okay, there are other cases, right? Plain view is an important Fourth Amendment term that says that things that are in plain view can be searched and seized, provided that there is probable cause to do so. But this case dissects what is the meaning of plain view.
And establishes that it has to actually be probable cause. That's like such a key piece as well. So for instance, like if it was a crack pipe that's sitting out there and you just know by looking at it that's an illegal item or whatever, that's different, right, than having a stereo anyways.
No, it's a super important point, and I want to dig into both the majority opinion of the case as well as the dissent to understand what that means. But let's fill in the rest of the details. So at the trial level, defense counsel files a motion to suppress.
And let's talk about that for a second.
Is held. Go ahead.
Yeah, how that process works, right? So you're going to trial on a case, and you have a Fourth Amendment issue for search and seizure. You don't just go to trial and argue that in front of the jury. You file a motion ahead of time called a motion to suppress, which is to suppress the evidence that was illegally obtained due to some violation of a constitutional right. So this happens before trial. They argue this to the judge. The defense attorney says this was a violation of the Fourth Amendment in the way that they received or found this evidence and found it to be illegal. And the judge agrees.
Right. So at the trial level, again, defense files a motion to suppress. A hearing is had. The judge says, yes, the officers acted illegally. They should not have conducted that search in the way that they did. Even though they later got a warrant to go in and seize those things, the search itself was unlawful. So then the state appeals that suppression order, and they can do that. So they appeal that to the Arizona Court of Appeals. The Court of Appeals agrees and says, yes, the officers there acted unreasonably, violated Mr. Hicks' Fourth Amendment right to privacy. Therefore, suppression stands. Arizona Court of Appeals affirms the lower court's order. Okay. Now, going back to what you mentioned earlier, how does this case then get up to the U.S. Supreme Court? Well, in Arizona, the next highest court is the Arizona Supreme Court. The state, the prosecution, petitioned for review, meaning they said, we disagree with the Arizona Court of Appeals decision. We want the Arizona Supreme Court to weigh in. We want to go one more level up. The Arizona Supreme Court in this case denied review. They said, we're not looking at this, which means the decision of the Court of Appeals stands. The item is suppressed, the evidence is suppressed, and Hicks prevails.
Meaning it's suppressed in trial. It can't be used against him, and so there's really no case against him.
Correct. And what's interesting is we're not really talking about the shooting anymore. We're really talking about the evidence of the stereo equipment as it relates to a prosecution for theft, robbery, armed robbery, whatever it is that they had a reasonable basis to seize those items, right? Okay. So how does it get to the U.S. Supreme Court? Well, because this is a constitutional issue, a Fourth Amendment issue, and because it had already been decided by the state's highest court, then they can appeal to the U.S. Supreme Court as a way to review both the Arizona Court of Appeals and the Arizona Supreme Court's decision.
And that's probably something a lot of people don't really think about, right? Is that if you go to the Court of Appeals, they give you a ruling you don't like, you can then appeal it to the Arizona Supreme Court. People don't realize sometimes the Arizona Supreme Court can say, no thanks, we don't want to hear this, right? And that you're not just stuck there. At that point, you can go to the United States Supreme Court, which is really exactly the same as the Arizona Supreme Court in a lot of ways. They can say, no, thank you. We don't want to hear this case, or we don't want to, really hear it or put it in front of them. But they do.
Yeah, and that's what we call discretionary review, okay? So the Arizona Supreme Court did not have to take review, and they didn't. But curiously, the U.S. Supreme Court saw an issue that they believed needed to be fleshed out in a deeper way so that there can be a better understanding, more clarity as it relates to the Fourth Amendment. Or perhaps, if you're Justice O'Connor, less clarity, right? Because she is part of the dissent, and she vigorously argues that the majority holding, which was by Justice Scalia, says, or she argues that they're incorrect. And so we're going to debate that.
And she's the Arizona, representative. Not that there's representatives.
Former Court of Appeals judge in Arizona is Justice O'Connor, eventually elevated to the U.S. Supreme Court. But yeah, Arizona.
Yeah, and that's interesting, right? Talking about why. Why would the U.S. Supreme Court take a case in the first place? But especially in a case like this where the Arizona Supreme Court said, no need to take it. The U.S. Supreme Court, as you mentioned, looks at cases and says, look, we've got cases all over the country. We've got states all over the country making decisions on the U.S. Constitution, Fourth Amendment. And sometimes they come out a little bit differently. Sometimes they feel there needs to be a clarification made, and they thought that was the case here.
So I want to read a little bit from the U.S. Supreme Court opinion. Again, this is from the majority opinion. This is from Justice Scalia. He's an interesting character to me. He is somebody who is known for sort of a rigid textualism, meaning the words of the Constitution matter. It's not a flexible document. It means what it says it means. And he's what they call a strict constructionist, okay? So not somebody who is going to, break out of the mold much. And interestingly, someone who in these circumstances is quite protective of individual rights. He is in favor, at least in this case and in many others, of preserving individual liberties against police intrusion, against government intrusion. Okay, so a couple of things. On the topic of why did the U.S. Supreme Court take this case, they tell us why. We granted certiorari or review in the present case to decide whether this plain view doctrine may be invoked when the police have less than probable cause to believe that an item in question is evidence of a crime or contraband. So, first of all, if officers are doing a search and they see something in plain view during a legal search, an otherwise legal search, what is the standard that police have to have in order to say that that item of that piece of things, is it evidence, is it contraband? Scalia lays out that it's very clear they have to have probable cause.
In order to do an additional search of it or seize it, right?
Yeah, and I also want to read a little bit of how this court frames the facts. It says, one of the policemen, Officer Nelson, noticed two sets of expensive stereo components which seemed out of place in the squalid and otherwise ill-appointed four-room apartment. Suspecting they were stolen, he read and recorded their serial numbers, moving some of the components, including a Bang & Olufsen turntable, like we said, an expensive record player. In order to do so, which he then reported by phone to his headquarters, on being advised that the turntable had been taken in armed robbery, he seized it immediately. It was later determined that some serial numbers matched, and then a warrant was later obtained. What's interesting about Scalia's interpretation of, and the state actually concedes this.
And that's big too.
Right. So the state in their hearing, perhaps down below or perhaps at the oral argument in front of the Supreme Court, conceded or agreed that the police didn't have probable cause as it relates to the stereo equipment, but instead had reasonable suspicion.
Right, which is just a way of saying they didn't have as much information to know or be as sure that this was an illegal or the result of some type of illegal act, right? So they had reasonable suspicion based on his observations, but they agreed or admitted that they didn't have probable cause, which is also not a terribly high standard. It's in order to arrest somebody, you need probable cause, but it is a higher standard. And they said, yep, didn't have probable cause, which really bit them.
It did, and one of the dissenting justices, I can't remember if it was Scalia, or O'Connor, or was it Stevens? Who was the other one? Give me just a moment. It was Justice Powell. Says that he disagrees that the state should have conceded the point on reasonable suspicion.
And O'Connor says that too at the end. Like, she makes all these arguments and then says, plus, I thought they actually had probable cause.
Right. So we could have a debate on whether what that officer knew at the time actually amounted to probable cause. I would argue that he didn't. Just because something looks out of place doesn't mean you have probable cause to believe that that is a criminal piece of evidence.
Especially when you say that's the same type of evidence you need to arrest someone. Correct. You think he had enough information to say, that looks out of place, you're under arrest.
And I think also it's almost like a puzzle. You put the puzzle pieces together and yeah, I'll give you probable cause on that. What's the puzzle piece? Moving that equipment, reading the serial number, checking back at the ranch. Does that match something that we're looking for? Yes, it does. Boom. There you have probable cause to seize.
Yeah, and they're saying in order to get to that level, he had to do an additional search, and so you can't do that in between having, it's a little complicated, but in between having reasonable suspicion and probable cause.
And I want to clarify something that I had kind of messed up earlier. I had interchanged the words searches and seizure. Was this a search? Was it a seizure? And I'm going to clarify what Justice Scalia says. He says, Officer Nelson's moving of the equipment, however, did constitute a search separate and apart from the search for the shooter, victims, and weapons that was the lawful objective of his entry. So moving that equipment is a new search. And do you understand that? I mean, we have to think about that for just a second. Going into the apartment under exigent circumstances, looking for the gun, looking for a suspect, whatever, that is a search. It's a lawful search.
It's justified by the shooting situation, right? And that's the important part too, is to say, obviously, stolen equipment is independent, is separate of the shooting issue.
Right. And that's what Scalia takes issue with. He says, but taking action unrelated to the objectives of the authorized intrusion, which exposed to view concealed portions of the apartment or its contents, did produce a new invasion of the respondent's privacy unjustified by the exigent circumstance that validated the entry.
Yeah, and it's hard because I can already hear people saying, like listening to this and saying, oh, this is a technicality where you're saying he doesn't get to do police work because, you're saying he wasn't allowed to search that, even though he had reason to believe that that was an illegal item. And here is the function of the court in so many places, is to say, I am going to protect the rights of people, of individuals, from an unreasonable search or seizure because we value that freedom and liberty of the people to be free from those things.
And I think to do so otherwise, or not to do so, is a continued erosion of your rights, of my rights. Yes, we can look at this and we can say, well, what did he do? He moved a thing 2 inches to look at the serial number. Big deal. It is a big deal because that involves my privacy right, your privacy right, and the invasion of the government into my home, looking at my stuff, even though they may be there for a righteous reason and lawfully. But if they start doing something out of bounds, Scalia says, no, we're calling them on that.
Slippery slope, right?
Slippery
You say,
slope.
okay, that's fine. Now what? Now, if as long as there's a legal reason to be in there, they're just going to toss the whole house, right? I mean,
then what does the Fourth Amendment mean? Right. It loses its meaning to me. If you don't put up these these barriers against police conduct, where does it end? Everything becomes reasonable. I love this, kind of a soundbite from the court's opinion. Again, he says, a search is a search, even if it happens to disclose nothing but the bottom of a turntable. I love that.
Yeah.
Because now that little piece of evidence is protected. Yeah. Okay? All right. So in terms of the Fourth Amendment, right, you have to determine, is this a search? And then is that search reasonable, right? So that's the next element of the evaluation. Scalia goes on to say, it's well established that under certain circumstances, police may seize evidence in plain view without a warrant. We know that. And then he goes on to say that we now hold that probable cause is required. In order to seize something, you've got to have probable cause. And we just did the math there with that puzzle analogy I gave you. They didn't have probable cause to seize that equipment. Agree?
Right. And I think, again, you can you think of some examples where somebody goes into an apartment or whatever, a home, and has a reason to be there, and they see something that has absolutely nothing to do with it. The most common thing that you see is illegal drugs.
Sure.
Right? I mean, to say...
drugs, weapons.
Yeah. That it's absolutely... There's no further investigation that's needed to find out if that's an illegal, item to possess.
Yeah, because on its face, especially drugs, you can see that that is something that just the law prohibits it in general, right?
Yeah, that's a great point. It's a possession. It's just a status crime, not status, but possession crime.
Yeah, cocaine is illegal to possess.
No matter what.
And if you see something that looks like cocaine, even if you haven't tested it, if you've been trained as an officer, this is what cocaine looks like, and you see a baggie that has the indicia of cocaine in a place, in plain view, I would argue that you do have probable cause. Now, some may say, well, you got to test it first. Well, that presents a practical problem.
And that's a higher standard.
Right.
Yeah.
Scalia pretty much quickly resolves the opinion after that. He says, look, probable cause is required. These guys didn't have probable cause. They conducted an additional search outside the scope.
They admitted to not having probable cause.
They admitted, and that's where the state, I think, fell down, was they said, the officers had reasonable suspicion and nothing more. And so he quickly resolves it, saying, hey, it's suppressed. Court of Appeals, they got it right really for the wrong reason, and I'm not going to get into that. It was a little bit of a technical standard that they used. Scalia says they got the right result. Suppressed, and so Mr. Hicks wins, and that's the majority opinion.
And from now on, that's the rule, right? Throughout the land of the United States, whatever state it's in, says in order to do that next step of a seizure, you have to have probable cause.
Agreed. Now, because Scalia, I think, is a thorough jurist, or was, I know he's passed, he goes on to sort of critique both Justice O'Connor's and Justice Powell's dissent, and I'll just give you, two comments about each one. One comment about each one. He says Justice O'Connor somehow splits hairs and says, that's not necessarily a search. She says this was a cursory inspection, and Scalia says no, that's a search. And if we start dividing, well, what's a cursory inspection versus a full-blown search, where do you draw the line? So that's his critique there. And then with Justice Powell, he says, well, his is more of a practical argument, like what are law enforcement officers supposed to do? You're kind of, cutting their legs out from underneath them. He says, there is nothing new in the realization that the Constitution sometimes insulates the criminality of a few in order to protect the privacy of us all. I love that.
That was my soundbite.
Love it.
Right there. Oh, read that again. I
okay,
love that.
Again. And I think this is something that you and I as defense lawyers fully, wholeheartedly agree with. We've said it a number of times. We represent individuals, people in circumstances. And so he says, there is nothing new in the realization that the Constitution sometimes insulates the criminality of a few in order to protect the privacy of us all. It's great.
It's a price we're willing to pay as Americans.
That's right. And so sometimes the police have to lose. And you know what? Sometimes the criminal goes free. But if doing so protects our liberties and upholds a greater standard of freedom for all of us, then we're all better served, even though Hicks may have gotten away with a nice turntable.
Yeah, and in the vast majority of situations, they just have to do it right. They just have to take a couple extra steps, in order to do it without violating people's rights.
Yeah. I know sometimes we kind of steer away in this show from really offering our opinion about things, but I'm going to agree with this wholeheartedly. I agree with the way Scalia handles this. I love how clear and how protective he is. I think it's great. I know a lot of people, he's got his own critics in other situations, but whatever. But I sincerely appreciate the upholding of individual liberties here. Now, let's dig in a little bit into the dissent, because I think it's interesting.
And I love how he preempts the
totally
the dissent.
Good lawyer will preempt.
So
it.
how it works, as far as the process, like they're giving their opinions. They, everybody who's in the majority, who's dissenting, or are they going to change and join the majority? There's kind of this thing that happens, right? So he knows and everybody reads each other's opinions. So he knows that he's in the majority and he's writing, for the majority. And then we have people who are dissenting, and he knows what their arguments are. And so he adds to his opinion responses before you even get to the dissent. That's how it works in the opinion. We get to read why the dissents you're about to read
He gives them a little jab.
Wrong. Yeah,
right, it's so
I
funny.
like it.
Jumping into Justice Powell's opinion, and please weigh in, as you want to. He kind of says, Powell, he says a lot, but he says this court, talking about the majority, nevertheless holds that merely looking at an object in plain view is lawful, but moving or disturbing the object to investigate a reasonable suspicion is not. And he says that that's an untenable, unreasonable position to take. So Powell would say, hey, doing that
doesn't make a reasonable search unreasonable.
Right, it doesn't affect your constitutional rights. What's your take on that? I mean, it is a slight movement.
I mean, it's a smart argument to make. It's not like it's totally, devoid of any type of logic. Of course, anybody could look at that and be like, gosh, you're telling me this is a legal search, but if I do that, it's not a legal search if I just have to move it in order to see. But it just minimizes what that means in other, circumstances and situations where I would take the opposite view where he says that's untenable. I would say saying sometimes it's okay and sometimes it's not okay. That's what makes it just a useless rule, right?
And I think if you look at, remember, we're talking about the plain view doctrine.
That's a good point.
Okay.
Yeah.
Plain view. It doesn't say plain touch, plain move, plain look around, plain look underneath. It's plain view. If it's not in plain view, it's not in plain view. I mean, am I an idiot? I think that is what the words mean, what they say they mean.
Maybe that goes back to Scalia and his interpretation of words. But it also goes against it that he's creating a rule that's not in the Constitution as far as the probable cause requirement.
But what standard should there be?
No, I agree with it 100%. I'm just saying.
I think that's an interesting area for debate. Yeah. Is it reasonable suspicion, whatever? I mean, Scalia ultimately says we need a bright line. That bright line is probable cause. Powell wants to say, well, plain view might be something like that.
It says, they use the word of another case that talks about that officers rummaged through the person's items, or he makes the point that they didn't have to look in any closets or cupboards or cabinets. It was just in the room, and so that's plain view. But, if I can't see the thing that helps me, then I should be able to move it a little bit, right? I get it. It's not a crazy argument to make.
No, I think any of us would be hard-pressed to say anyone on the Supreme Court is crazy, right? I mean, they're learned individuals. Yeah. Here's that remark, though, and here's what he says. Indeed, the state was unwise to concede the absence of probable cause. How would you feel if you're the AG for the state who's arguing this at the highest levels, or you're the trial attorney down below and you concede that it's not probable cause? You have a justice saying the state was unwise.
Yeah. Had you not done this, it might have gone the other way. I think that it's, again, we always try to avoid armchair, quarterbacking, and especially in an oral argument to the Supreme Court. Are you kidding me? These are some of the highest level, smartest people doing this.
They're calling you unwise.
but
so
it's
can
tough.
I tell us a quick story?
Yeah.
When I was a prosecutor years ago, I tried a case I won. In closing argument, I had said some things that I shouldn't have said. They were a statement that was contrary to the law. And part of the appeal...
Accidentally, I'm sure.
I was a newer prosecutor. I was only, 2 or 3 years in, let's say. This case got appealed, and there were actually appealable issues in the case apart from my comment. It went up to the Arizona Court of Appeal, or Arizona Supreme Court rendered a decision in my case. And I was still a prosecutor at the time, and I went and watched the oral argument. And they spent, let's say, 18 of the 20 minutes talking about other issues that ultimately were the ones that caused the case to get remanded for a new trial. But then I'll never forget this. Justice Andrew Hurwitz says, what are we supposed to do with the prosecutor's egregious comments? I mean, he said some things that he really shouldn't have said. And I'm sitting there in the audience, and I was thinking, well, that was me. I shouldn't have said those things. And Hurwitz over here is calling me out on that. I feel like perhaps this lawyer would have felt down below the state was unwise. I was unwise to have said those things. So I felt about this tall.
Well, let me defend you on that. You gave enough of a crap to be there and learn about it, right? We've seen so many prosecutors. We've talked about one prosecutor in particular who gets multiple remands over and over again and continues to do it until he lost his...
Well, he's no longer licensed. And the good news is I still have a law license, and I can still practice law. But I appreciate that. That does actually make me feel better. And you can bet that I never committed that error again.
Exactly. I mean, it happens. You know what I mean? And it comes from kind of your intent. These are imperfect people, doing these trials. And what just burns me up about prosecutors is ones that do it on purpose. They know it and do it on purpose.
They try to skirt the line. Okay, so let's wrap up here in a second with Justice O'Connor. I certainly want to do justice to her dissent. She takes issue with the idea that this was really a cursory examination. She's kind of in the same camp as Justice Powell in terms of it's not a big deal. What they did really was not that impactful.
Yeah, to say, hey, look, in plain view was an item that, given the circumstances, was suspicious, right? It looked like it, and so he did some minimal work to be able to view a serial number and check it out and see. And then the other point that she made, not to jump ahead, was, again, like we talked about, that she actually thought they had probable cause, based on that.
Well, and she argues that there ought to be sort of a second sort of level or standard for sort of cursory examination. So if a search requires probable cause, she argues that a cursory inspection, one of these numbers, if supported by reasonable suspicion, is reasonable. So now she's creating this other tier of plain view, which Scalia disagrees with. She says this: in my view, the balance of the governmental and privacy interests strongly supports a reasonable suspicion standard for the cursory examination of items in plain view. The additional intrusion caused by an inspection of an item in plain view for its serial number is minuscule. Indeed, the intrusion in this case was even more transitory and less intrusive than the seizure of luggage from a suspected drug dealer, yada, 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 to use a line from Seinfeld, right? So she's creating sort of this second tier where she can say, hey, if there's reasonable suspicion to support a minimal intrusion, then it ought to be okay. Again, Scalia says, no way, it's reasonable, it's probable cause or nothing.
Yeah, I thought her interesting piece, too, was, remember we talked about, I guess I made gave my opinion that it doesn't normally just excuse criminal behavior to say that you can't go search things that you suspect are illegal. You just have to go through the process, right, and do more investigation. She actually takes issue with that, right, and she says, what were the officers to do in this case? Had they done what the majority in this opinion said, then he would not have been able to find those the serial number and find out if they were if it was stolen.
That's really interesting to me, because if I play that out in my mind, so officer goes in, they seize whatever guns, whatever. They then see the stereo equipment. They can't link the stereo equipment yet to a crime. So what do? They go back, they write an affidavit, they write a search warrant. The search warrant, I believe, may or may not get granted. There's not necessarily a nexus to criminal activity. Crappy apartment, expensive stereo equipment. Does that mean there's probable cause to do a search warrant? I don't know that there is. I mean, maybe this guy loves stereos. Maybe he spent all of his money on expensive stereos. Does that mean that he committed a robbery or a theft of some sort?
And I would say, hey, he could still do some investigation. Say, hey, any robberies recently with these exact... In fact, I could look at the model number that's visible to me. I could look at everything that's visible to me. I could take pictures, potentially. I don't know if you could take pictures. I think you could take pictures.
Could you take
and
pictures?
Send
I
them?
don't think the pictures are a furtherance of that search.
As long as you don't move it,
you
right?
Don't move it.
You take it and you send it and say, is there anything we've had around here or whatever? Or you take in the suspect at some point and you say, hey, here's the shooting. Also, we found the stolen stuff in your apartment. Who'd you buy that off? I'm guessing you
Right, a clever cop could get him in the room. I mean, you've got probable cause to arrest him at least for a discharge of a firearm, possible aggravated assault, endangerment. Also, Mr. Hicks, I noticed that you've got some stolen stereos, not knowing that they're stolen, but being a good cop, right? We'd love to return those to the owner. Tell us about that.
Which is, why we always advise people.
Right.
Don't talk to the police.
And if you're Mr. Hicks, right, in 1984, you would have, called a lawyer and exercised your right to remain silent.
Because you would have seen our videos and you would have known.
Well, I don't know about 40 years ago. All right. Well, great discussion, Ryan. I appreciate it. A little bit more lighthearted in terms of facts, but super important with regard to our clients' rights and really all of our rights as U.S. citizens.
Absolutely. I mean, this is a lot of the reason, this is where we live a lot of times, is kind of challenging these and making sure that people's rights weren't violated in order to, justify some type of search or some type of an arrest.
And that's one of the many reasons I think that we both love defense. There is a lot of, I think, fun in this work, but it's also serious business. So,
yeah, and again, people sometimes get the wrong idea about what we do. And they're like, how could you defend criminals? When really, to me, it really is about, I have to make sure that every arrest, every trial, every, criminal charge was done right, because, they talk about, they say, if you can violate, somebody's rights in order to get the arrest and do what you think you should have done, then we're all really in trouble.
That's right. It reminds me, and I told you this, that even my own mom has questioned what I do. She says, David, how do you defend somebody that's guilty? Mom, this is for you. This is why I do it. Thank you.